2022 CR 2353, State of Texas versus Concia Roper. Can our parties approach? And the parties should state their name for the record.
Anthony Cantrell for the defendant.
Michael Villarreal for the state.
And Judge, this is a continuation.
I remember. Yes, thank you. My mind is a steel trap.
That's good.
All right, and are you Ms. Roper?
Yes, ma'am.
All right, we had begun the plea in this case, and where we stopped was I was going over the plea agreement. So has the plea agreement changed since the last time I began?
Yes, Your Honor. Specifically, as it relates to the agreement as far as an affirmative finding of family violence, we are asking that the document reflect that the state is not seeking an affirmative finding of family violence on this case.
All right, if you all want the paperwork to reflect that. All right, Ms. Roper, I'm showing you what's entitled plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
All right, and just so the record can be clear, previously I've stated that the defendant had knowingly and voluntarily waived her right to jury trial. According to the plea bargain agreement, there's a $1,500 fine. The state recommends deferred adjudication, and they're asking for the VIP course. Did you understand that to be the plea bargain agreement?
Yes, sir.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There'll be a top evaluation, 120 hours to community service restitution, no contact with Charles Mayberry, Mayberry, and no firearm possessions. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Your Honor. At this time, state up for state exhibit number 1 and its attachment.
Any objections?
No objections.
Ms. Roper, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept it to evidence, states exhibits 1 and attachments, or review the same.
Yes, ma'am.
After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty in the court. It will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
If we can, Your Honor, that would be great. One other thing, Your Honor, they do have 2 children together, so only with respect to when they're.
Well, first, are we proceeding with sentencing?
Yes, ma'am.
All right, anything you wish to say on behalf of your client?
No, Your Honor, we'd ask that you follow the plea bargain.
All right, so you were talking about the 2 children they have together?
Yes, so just during the exchange, if there could just be no harmful or injurious contact or any other matters that might arise with respect to the care of the children, no harmful or injurious contact. Otherwise, there is no other relationship.
All right, Ms. Roper, what are the ages of your children?
My daughter shall be 5 this month, and then our son will be 2 in August.
All right, is Child Protective Services involved?
No, ma'am. We're just passing children through both of our parents. That's how we've been doing.
So CPS wasn't involved at all?
No, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I'm the lead cook and prep for Gus's Fried Chicken.
Is it chicken good?
Yes,
Is it better than Southern Classic?
it's cooked in peanut oil, so yes. But come and try it. I make all the sides. So
Have you
go
tried
ahead.
Southern Classic?
I'm from Biloxi, Mississippi, so we Southern classic all the way.
Okay, so I think we're gonna have a little debate. We may need to have a debate over the best chicken, but okay. I have been to Gus's and it was good.
I'm gonna have to try it now.
I can't believe you have not tried. How long has he been representing you? You should support your client.
Absolutely.
It's
Your
right
Honor.
around the corner. I don't see why. We get a lot of you guys in there. I'm y'all's cook. So
The wait is
when y'all
long.
eat, I make it.
The wait is long. All right, this is what I'm going to do. Sentence you to 4 years deferred adjudication. There's a $1,500 fine that will be probated. The BIPP course, parenting classes, proof of employment within 30 days. There should be no employment as a home health care provider or with minors. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do with the booster shot, 40 of those hours will be waived. The remaining of the hours will be waived once you complete parenting classes. There's to be no contact with Charles Mayberry outside of custody exchanges usually go wrong. And let me just tell you why custody changes go wrong. And this is based upon my experience as a defense attorney and a prosecutor. It goes wrong because people always want to bring extra people at the custody exchange. And usually the extra people they're bringing are their new girlfriends, their new boyfriends, and things just go haywire. So you are going to continue to do your custody exchange to your parents. And grandparents are great. I think they enjoy seeing their grandchildren as grandparents to spoil them. So there's going to remain in no contact with Charles Mayberry. I'll reconsider that once she's been on deferred adjudication for a while and I can see how things are going. And
Thank you,
maybe
Jeff.
after the parenting classes. So no contact with Charles Mayberry, no firearm possession. If you're drug tested today, what are the results going to be? All right, we got to stop using the marijuana, you understand? I don't want anyone cooking my chicken to use marijuana. Maybe they'll forget to use the peanut oil and use Crisco or something, okay? Not that there's anything wrong with Crisco. So I want her tested for levels. And so those levels should start going down. There's going to be regular reporting in person or Zoom. We'll do field visits one time per month for 6 months. And of course, if everything goes well, you can discontinue the field visits. Is there anything else, probation?
Your Honor, did you say anything about a tap? Did you want a tap?
No, we'll just see how these UAs go. But if those levels go up, we may end up doing something else. It's not gonna happen, you're done.
My children is more important to me than smoking a blunt.
Yes. All right, is there anything else? Is there anything else you need from the court in order to be successful?
Other than, you've already said what you had to say about the contact between me and
Yes.
Charles. So,
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
yes,
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you now have the court's permission to appeal. Do you understand?
yes, ma'am.
All right, we can go off the record. So here's the thing. You have a 5-year-old and a 2-year-old. 5-year-old and 2-year-old, their children are pretty simple, I've discovered. 2-year-old wants to eat, wants their diaper changed, wants you to say you love them, bounce them, and they don't want chaos in their life. And when parents bring chaos into children's lives, that becomes the expected thing. So your actions teach your children what's appropriate. So when you see children who use profanity, You know why they use profanity? They learn that from their parents. So everything that's happening in these formative years for your children, they're mimicking you. So make sure they're mimicking good things. Do you understand? All right, good luck to you.
Thank you, Judge.
2022 CR 5352, State of Texas versus Paul Vasquez Jr. Could I have parties announced for the record for the state?
Hank Wilson for the state, Your Honor.
Defense?
Jane Seeloff for the defendant.
And are you Mr. Paul Vasquez Jr.?
I am.
I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes,
You're going to need to speak up.
yes, ma'am.
All right. Are you saying Paul Vasquez Jr., who was placed on community supervision in 2022 CR 5352 for the offense of felon in possession of a firearm on August 25th, 2022 for a term of 2 years? Is that you?
Yes, it is, Your Honor.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Paul Vasquez Jr., did then and there fail to report to the supervision officer as directed for the months of June, August, and September 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And Your Honor, we waive the other violations alleged in the motion.
Any objections?
No objection. That is our understanding, Your Honor. Thank you.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 2 years in prison and up to $1,000 fine?
Yes, I do.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant on probation, but we're asking that you follow the court summary recommendation to extend the probation for 1 year with SATIF held in abeyance. We're asking for intensive outpatient treatment with weekly UAs for 60 days, 0 tolerance on skipped UAs, and we're asking for a felony drug court evaluation while in custody, Judge.
That is our agreement, Your Honor.
All right. Mr. Vasquez, can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
So help me God. Yes, ma'am.
All right, you can lower your name, state your name for the record.
Paul Vasquez Jr.
All right, why are you not reporting?
Ma'am, I had told my probation officer that my father, 79 years old, he owns a business out there in Austin, and I asked for permission to my probation officer, and at the time, Austin's traffic was kind of hectic, and I'm not a violent person or anything, so I panicked and when I missed that appointment, I honestly just panicked. So there was nothing that I was hiding or anything. I called her, and again, I was just working in Austin and coming back and taking care of my father. My father is in the hospital right now, has his leg amputated. He's 79 years old. So I'm just, trying to get back on my feet also.
So how is going to prison going to help your father?
It's not, ma'am. It's not.
Because that's what you're asking the court to do by your actions.
Yes, ma'am.
Because you didn't report June, August, and September. And I know traffic is bad in Austin, but it's not that bad. It's not 3 months bad.
I understand that, ma'am, but I do apologize for that. And
So what drugs have you been using?
I haven't been using no drug. I've been clean for at least 6 years already.
So, and I'm not going to take this as true, but according to the motion to revoke, you haven't been doing your UAs either.
Yes, ma'am, I haven't.
So why haven't you not been doing your UAs? And there is no father excuse or I'm working excuse.
There's no father excuse or anything. It's just the money wise. Like I said, I was just trying to get back on my feet and whatnot. And my father is real strict on me. He won't provide any money for something that I've,
No, but you've been making money because that's what you said you were doing. You said you were in Austin working.
Yes, ma'am.
So you've had your own money. So it still doesn't explain to me, allegedly,
Yes, ma'am.
why you're not reporting in March and in May for drug testing.
For drug testing. Oh, well, on one of them, I did tell my probation officer I did take it, but what do you call it? It wasn't filed or something, but I did take that first one that I was assigned to. And the other two were, I admit I didn't go on those.
Okay.
And those are the only ones that I was assigned to, and I did go to one of them. And I showed her the receipt to one.
All right. So he's telling the court that he doesn't have a drug problem. So why are we holding SATF in abeyance, and why are we recommending felony drug court? Probation.
Was one of the original, establishment, was one of the original.
So has he done intensive outpatient treatment? Has he done any type of treatment?
No, Judge.
TAP evaluation done?
TAP recommended intensive outpatient treatment, Judge.
Okay. All right. Is there anything else from either side?
It's just that, that's why we want the drug testing to make sure that we show the court and the probation officer that.
That final speech? That's not just a lecture, that's a warning wrapped in life advice. The judge is connecting the dots between choices and consequences, not just legally, but generationally. This wasn't just about a case file, it was about two kids watching their future being shaped in real time.
That he does not have a drug problem, and we can go from there. But if he does have a drug problem, then we need to meet that. So I would ask the court for just one more chance, and he understands that this is it.
Yes, Your Honor. Oh, I do agree on that. Just to prove my innocence on that part, that I don't have a drug problem anymore.
Well, what was, you say anymore, what was your
When
drug
I was
before?
a kid, my juvenile years,
All right, this is what the court is gonna do. The court's gonna find violation of condition number 4 true, deny the motion, alter and amend conditions to include intensive outpatient treatment, extend for 1 year. There's to be a referral to felony drug court while in custody. So if felony drug court doesn't accept him, then he'll be intensive outpatient treatment. And there's to be the UA hotline until further notice.
Thank you, Your Honor. I appreciate it.
Thank you. Is there any